Good morning, everyone. Welcome to the Beto Chair Lecture Series. First, please allow me to briefly introduce the history of the Beto Chair Lecture Series. The Beto Chair Lecture Series was established by the Houston Endowment in 1981 in honor of Dr. George J. Beto, the former director of the Texas prison system and a professor here at SAM. Since its creation, the series has featured dozens of prestigious scholars who have presented their research to the students and the faculty of the College of Criminal Justice. Today, it's an honor and a pleasure for me to, in my capacity as a Beto Fellow, to welcome Dr. Philip Reichel as our Beto Chair Speaker. Dr. Reichel is an emeritus professor at the University of Northern Colorado, and he currently serves as the ACJS NGO representative to the United Nations and is chair of the ASC's International Division. Earlier this year, Dr. Reichel was awarded the Gerhard Müller Award for distinguished contributions to international criminal justice. And the next month, he will receive the Senior Scholar Recognition Award given by the International Association for the study of organized crime to scholars who have made significant advances in the study of organized crime. Dr. Reichel's primary research areas have been in comparative justice systems and transnational crime. He is the author of Comparative Criminal Justice System, a topical approach, editor of Global Crime, an encyclopedia of cyber theft, weapons sales, and other illegal activities, co-editor of the Transnational Crime and Global Security, and co-editor of the Handbook of Transnational Crime and Justice. Please join me to welcome Dr. Reichel to Sam Houston State University as our Beto Chair Lecturer this academic year.
Thank you very much, Dr. Zhang. I appreciate that. Thank you all for any role that you might have had in me being here today. I know a couple of my friends were doing some arm twisting to get me to be selected as this. It's a very prestigious, as you know, opportunity. I have had the pleasure of having known several colleagues who have been the Beto Chair Lecturer, and I have been able to count as my friends, some of your former deans, and just happened to have a chance to meet your current Dean Lyons. And as I don't need to preach to the choir here, but students that I've been able to encourage to come to Sam Houston State for criminal justice and colleagues that I know, graduates from here, just always impresses me the extreme professionalism and collegiality that Sam Houston instills in its graduate students and its faculty. So it's truly a real pleasure to be here, and I thank you for that. I am in an area that isn't known to everyone. Comparative and international criminal justice doesn't have the rep necessarily as courts, corrections, and policing sometimes does. So when I'm asked to speak, I sometimes like to start off with why is he here, basically. And I like to refer to the comment that was made by former Attorney General Edwin Meese when he said that an expert is someone who is more than 50 miles away, has no responsibility for implementing any of his suggestions, and shows slides. And this are things that I do meet in terms of being an expert. And so if you will bear with me to be an expert on international and transnational and comparative crime and criminal justice issues, it would be my great pleasure to be able to walk you through some of these things. I am not going to go in depth on any particular study, and I know that some of the Beto lecturers have been able to tell you about their particular studies and methodologies and so on. And I understand that this particular series, maybe this semester, next semester, is looking at research methods. And so I'm hoping that what I can do, instead of giving you in-depth information about a particular area, to give you more of an overview of the types of things that are possible within the area of comparative justice specifically, and looking both at comparative criminology and comparative criminal justice systems. we're going to begin with identifying the goals. I'm trying to, being an emeritus professor means that I'm very old. And it also means that I'm going to have trouble reading the screen back there. So I'm going to be turning my back to you on occasion just so I can see what it is that I've got written up there. The goal is to encourage researchers and teachers to start incorporating more international and comparative stuff into the classroom. I know that not all of you necessarily are going to go on to research careers or to R1 universities that are going to be responsible for doing lots of grant getting and so on. But even those people, I'm hoping, will also, when they are teaching the occasional class, will be thinking about maybe incorporating more comparative and international material into the classroom. That's material that I'm getting a little bit further along, and I'm hoping to be able to make it in the time that I have this morning. But if not, I'm also hoping that my opportunity to talk to the graduate students afterwards, if I don't get to speak very much about the integration of comparative material into the classroom, I'm hoping that maybe we can get some questions on that area as well, because that's really what I'm particularly interested in. I think the research part is certainly important, and I've enjoyed the research that I've done in that area, but I've really enjoyed introducing undergraduate students, and graduate students as well, to comparative and international issues, and I think it's something that is very important to have in the classroom. The means by which I'm going to try to accomplish this is to examine comparative research methods, doing it rather broadly with just a few examples in some of the areas. And then, again, if time allows, to show you how you might be able to incorporate into the classroom some of these types of issues. There are a variety of benefits to incorporating a comparative methodology, some of which include increasing intercultural competence, establishing points of contrast and cooperation, both neighbor cooperation and international cooperation. I'm going to concentrate today on the second one, establishing points of contrast. I think it's important for us to understand, and just the feedback I got from my students, understand how the United States system is similar to and differs from other systems. It's a way for us to not only understand our own system better, but to see opportunities for maybe change or improvement or patting ourselves in the back, whatever it might be. So we're going to look then at comparative methods. We'll do this by looking especially at, as I said, the benefit section and establishing the points of contrast. As we said, or as I just said, the idea of being able to have something to compare us to, I think, is very, very important. And as we'll see in a few moments, we can do that historically, we can do it contemporarily, we want. The US system is not the only one possible, nor necessarily the best system possible. My wife and I were at Greeley, where I'm from, the city of Greeley, had an Oktoberfest a couple weeks ago, and she was introducing me to one of her friends, and happened to mention that we were coming to Texas, and of course the person asked why, and told about my presentation, excuse me, and she said, well, what is comparative criminal justice? And of course you have a different answer depending upon how much background you think the person you're talking to might have. And so I said, well, basically what I try to do is look at how police, courts, and corrections vary around the world. And the response from this woman was, well, I thought that the United States was pretty much what everybody else copied. This was not the time or place for me to suggest that that was not true. So I simply said, well, yeah, there are some places where we still might be able to learn, but it certainly is true that the United States does have especially in the mind of people from the United States, has a reputation of having the best criminal justice system in the world. So we sometimes have to work with that kind of philosophy or presentation when we're beginning this. So today these are just the three that I use in my textbook on comparative criminal justice. A historical, political, and descriptive approach. And I want to walk through each of those three approaches and just give you a quick idea of the kind of topic that could be covered under each of those approaches. We're going to look at slave patrols as an example of historical approach. We're going to look at adjudication as an example of the political approach. And the descriptive approach, I'm going to briefly mention some death penalty information. Now, each of these are areas that I have either written about or done direct research on. But as I said before, I'm not going to spend a lot of time explaining the methods involved and the kind of procedures that we use. I would rather just give an overview. So today we're going to, as I say, look at historical with slave patrols and then adjudication and describe things. We start with slave patrols. When we're looking at the history of policing, my first teaching assignment was in, well, not assignment, I got to choose it. My first teaching location was in Augusta College in Augusta, Georgia, now Augusta University. And I was an Air Force brat, so I got moved around throughout the country. But my first long-term place to stay was in Nebraska and Kansas area. And so I consider that I pretty much grew up in the Midwest. And when I moved to, in my education, Kansas State University, Nebraska Wesleyan for undergraduate, and so on. So when I moved to Georgia, it was my first time living in the South. My first time actually even visiting the South. And one of the first things that occurred to me as I was going through my Intro to Criminal Justice class and preparing my lectures for those first couple semesters, well, quarters at that time, it occurred to me that everything that I was going to be talking about was northern-based and trying to describe the history of policing as being a British and a northern establishment that just kind of got not as much transplanted but adopted here. And I said, well, there must have been something going on in the South at that time. This was in 1972. So I was close enough to historical libraries in both Georgia and South Carolina that I was able to go read about slave patrols. And there was a little bit written in a variety of sources, some of which was criminal justice, but not very much, about the history of policing. Slave patrols were typically offered as an aside when talking about the development of policing. It's less true now. In looking at the history of slave patrol, my background is sociology. When I was going through school in the early 70s, there weren't that many options for criminal justice. So most of us were in sociology or political science or maybe psychology, and then we would be put in charge of criminal justice programs. So my background in sociology led me to look at this particular instance as an example of a social movement and how social movements might change given a variety of cultural impacts. And so I began looking at how the Southern slave patrols might have actually been a formative part of a more established and more modern kind of policing system. And I found a couple sociology theories that kind of backed up what I was thinking that I could be able to do, and I was able to, I think, pretty successfully do it, show that that the slave patrols became, I use the term, transitional policing system. And again, I won't go through all the specifics of it because the point here is more that this is something that comparative studies allows us to do. We sometimes think of comparative studies only in terms of comparing countries or regions. And I think it's important to remember that we can, within our own countries, go back historical times and see how what was happening back then might be influencing what is happening here. So in this particular instance, I happy to do 2 articles on this one. The very first one came out in 1998, and it was Southern Slave Patrols, a transitional police type. And then a couple years after that one, I wrote another one called The Misplaced Emphasis on Urbanization in Police Development. The belief that when we concentrate only on what was happening in the North, we tend to overemphasize the role that urbanization might have played in the development of policing. And since policing was developing in other parts of the country that weren't necessarily urbanized, there had to have been some motivation for things going on there as well. So these are the 2 articles that I did, taking in both cases a historical approach, not having much of a history background at all. We were fortunate to spend time with one of my old friends from Sam Houston, Mitch Roth, last night. He's having his eyes done today, and so I was happy that he wouldn't be here, pretending to be an historian. I'm not sure if he would particularly care for that, but I don't make any claims to be an historian, but I do like the historical method when being used for some of these kind of purposes. So the basic idea, understanding only one version of an event doesn't give us a complete picture, and that there are some implications that might be drawn from, in this case, the historical comparison. And I apologize for the black on blue. I was not sure what kind of a screen we would have, and I was kind of picturing a more movie-type screen. So this is not as easy to read as what I would like for it to be. So let me just bring your attention to what is under the second bullet and then the sub-bullet into that one. It says, slave patrols were created because of a master-slave social structure existing as colonies became increasingly politically organized as states, and elites were able to convince community members to police the slaves because control of those slaves was necessary to solidify elite positioning. And so given that, history of policing might help explain some of the aspects of contemporary policing. And I think this continues to be important. Unfortunately, starting about 6 or 7 years ago, this article was not read by anybody other than my mother for its first decade of, well, I would sometimes assign it in class just because I figured somebody had to read it. But it went on and on and on and never got any attention. And then as you'll see in a few moments, about 6, 7 years ago, for very, very unfortunate reasons, the article became very, very popular. And I started getting calls to be on podcasts and other kinds of interviews. And that also required me to go back and look at what I had written 30 years ago and remind myself of what kind of points I was trying to make. And as I was doing so, I became even more convinced that the kind of links that I was trying to make at that time were links that continue to be appropriate today. The other article, the misplaced emphasis article, more clearly argued about urbanization maybe being overhyped as being a universally used explanation for the development of policing. Possibly more useful, I had written, was to view policing as the result of a desire by citizens, whether urban or rural, northern or southern, to protect themselves and their property. The desire for protection may not be a reaction to urbanization effects, or maybe in one geographical area, but in some other location, it might be a desire to result from having runaway property being stolen, all of these kind of things. And by the way, when I was doing this in, in this case, the late 1980s, I was, I think, careful to make sure that the article also emphasizes the lack of compliance by the slaves and the riots and the other kind of things that were going on when the slaves were showing their displeasure with their slavery. And of course, this was in some ways part of the problem from the perspective of the slave owners and why you had to have policing, because you can't have riots going on, and you can't, and the slaves would typically try to poison their masters. There would be a variety of attempts to prevent the continuation of the slavery. And so it was this kind of interaction between the slaves and the slave owners and the other members of the community that gave a little bit different view on the way that policing developed, I think, anyway. So did the slave patrols desensitize Southerners especially to the idea of a police force, thereby allowing police to develop a little bit differently and maybe even more rapidly than it did in other parts of the country? Because slave patrols, as you may or may not know, were all drawn from the militia. You did slave patrol duty just as you did militia duty. And so having a very active militia in the southern colonies was necessary against, first of all, the Indians, and then the pirates, and then slaves. And so unlike many of the northern colonies, the southern colonies had this militia that was out and about and very visible to everybody. And this might have, in a sense, desensitized their community to having people playing this role in a way that it didn't influence the development of policing in the north. Military-like structure enforced the laws against blacks rather than whites, may have been viewed as less of a danger. And so the police structures developed in that sense. What kind of impact might that have? This is a quick aside for you. As you're thinking about writing your articles, you can't always anticipate 40 years from when you first wrote your article what kind of impact it's going to have. It said both of the articles that I did were on slave patrols. Only one had the title, or the word slave patrols in the title, and that's the one that is on the left-hand side This is Google things. So that particular one cited by 224 or something right now, but you can't see that. But over on the far left, that's not even that shows a black bar. That's not even when the article came out. That was starting in the 2000s or something. There were no bars at all when the article came out. But again, unfortunately, because of the reasons that this article became popular, you can see the increase in the number of citations for the article on the left, which has slave patrols in its title. The article on the right, I think, is equally important to slave patrols, but I didn't include that in the title. And so nobody, when they're doing searches, they aren't finding it. So when you're doing your titling and keywords and so on, think about that. Remember that 40 years from now, what words do I want to make sure that people, when they're doing their searches, will find when they're doing that? So, questions to consider today: knowing a little bit more about the history of policing, what might that influence us? So we're going to jump now to a little bit more contemporary stuff. The U.S., as you know, police kill more civilians at a much higher rate than do other wealthy countries. And again, I apologize for the size, but the United States is at the top row, and below that is Canada, and then Australia, it looks like, and we go all the way down to Japan, Iceland, Norway, and so on. So some people have wondered what kind of aspects, and maybe even historical, although they don't use that very often, might we be able to use to explain, in this case, police shootings of civilians? Am I too far away? Oh, there we are. These are not any surprises to you, although you might not know what other countries are doing. But some people have suggested that police shootings might be explained in part by training, by the availability of guns in the United States. Better training, some have suggested, could lead to a de-escalating, fewer shootings. Incidents of police shootings are extremely rare in many other countries, Finland being one particular example. And again, the chart's a little bit small. The top 10 countries with the highest gun ownership. This is civilian guns owned per 100 people. Again, the United States at the top, followed by the Falkland Islands, and then it goes down to Cyprus and Finland at the bottom. And so we have, in this particular instance, Finland being in the top 10 of countries that has a fairly high gun ownership rate, but Finland is also very low in terms of civilian shootings. Again, I'm just trying to give you an overview of how, if you were interested in comparative stuff, you could look at issues today and you could say, well, we can talk about the United States, we can talk about availability of guns and so on, but it's nice to have that point of contrast. It's nice to be able to say, well, what is the situation like in other wealthy countries, other democratic countries and so on. As you know, again, in our country, we have about 18,000 police agencies. There are no national standards for training and procedure. Many countries around the world have a university degree equivalent, and so most of the graduates of the university have chosen to go in policing, but the school they go to is not just a police academy, nor would it be getting a degree in criminal justice, for example. Although it could be something like that, but unlike our program with a bachelor's, master's, Ph.D.s in the area of criminal justice, for policing purposes specifically, there are many countries where you go to police college and you get your liberal arts background and training while you're getting your certification in policing. And again, I apologize for this, but at the very, very top, these are training for police internationally. The bar goes over to 4,500 hours of police training. And those top groups include places like Dubai, Finland, India, Norway is the one that's highlighted there. And those are all in the 4,500 range of hours per training for police. And then you drop down to the bottom and you have New Zealand, Bangladesh, Malaysia, and the United States at the bottom in terms of how many hours of training is typically required. And of course, we have so many different state certification procedures that we have to do an average of this type. And many of the other countries have a national police force, and so they are able to give an exact amount. We have to do more averaging. But anyway, you get the idea that there are some points of comparison that may allow us to better understand the kind of things that we're doing. Doesn't necessarily mean that we should change, but having an idea of what some of the other countries are doing can be beneficial. A professor from Norway Police University said policing is approached as an academic discipline in Norway. It's the same quality of education that we have for teachers, nurses, and so on. He was a police officer for 3 decades. The first year of police education in Norway is focused on the role of police in society and ethics. The second year, students show shadow training officers before returning full-time for a third year, which is focused on investigation and completing a thesis paper. And that's not unusual to have 3 years for a college education in Europe. So these are suggestions that some have made when they not only look at our own country and don't even have a point of comparison, but when we do a point of comparison, the idea that increased training hours could be of assistance, standardizing some kind of training, which we could do at the state level potentially, more so than what we currently do. The primary point that comparative studies may provide opportunities to find solutions that we haven't even otherwise even envisioned. So my encouragement is when you are a police chief, a mayor, a legislator, a governor, and so on, please consider including international or comparative perspective in your policing policy as you're going through that. Very quickly then, and again, I'm just giving you an overview of what you can do in each of the areas. The second area looked at political entities and how the various politics are able to influence the direction that aspects of criminal justice will take the different agencies. I haven't mentioned, and I hope that in some other classes you know that there are, sometimes it's identified as 4 different legal traditions in the world: the common legal tradition, the civil legal tradition, the Islamic legal tradition, or more broadly, a philosophical legal tradition. And then it's been kind of in flux. I like to think of it as an Asian legal tradition because of the region that it's covered. Some people have talked about a socialist legal tradition in the back. I just mentioned those, and now I'm going to say I'm not going to talk about those. But because there are different legal traditions, and whether you are in a common law country or a civil law country, or in some of the Asian countries, or in an Islamic country, that's going to certainly play a political role in how your justice system is established and set up. And when you do that, there are going to be a variety of policies that are influenced in trying to determine what direction some aspect of your criminal justice system takes. When we look at adjudication, for example, we can look at either the adversarial or the inquisitorial process. And you can spend a lot of time just doing that kind of a comparison and seeing how the process using the inquisitorial method is similar to and differs from the process using the adversarial method. Oops, let me go back to that one. The adjudication variations as well, and we'll come back to that in a moment. The way that the adjudicators are set up can either be a single full-time judge, as it oftentimes is in some of the Islamic countries. It can be a mixture of lay people and professionals, which is more commonly found, and it can be lay people only, which doesn't happen too often, but it is a potential, and depending upon what type of crime is being tried and so on. But let's take a look at that adjudication process first of all. The adjudication process, either adversarial or inquisitorial, are the ones that most people are familiar with and think about. And usually, it's just the adversarial, since that tends to be what we hear about. That's what we see on television. That's what our movies are typically made about. When I was teaching comparative justice class, I would oftentimes try to find a movie that depicted the inquisitorial system that would be a movie that would be of interest to the students. There are a couple out there, but not very many. Unlike the adversarial system, which pretty much any movie that you would like to show a courtroom scene in has the defense attorney interrogating the defendant, then followed up with the prosecutor doing an questioning and so on. So those are pretty easy to find. Finding something to show students that portrays the inquisitorial method, much more difficult. But in this one, and again, just an overview, since you're probably familiar with the differences, the adversarial system and the inquisitorial system, when you use it as a point of contrast and see the points of comparison, you can get some pretty good questions being asked by the students as to, well, then why did we choose to do it that way, or why don't we do it some other way? In this one, I'll just choose the second one then. How is truth determined? Well, under the adversarial system, truth is said to arise from competition between opposing sides, the sporting theory of justice. And we believe that the emphasis needs to be on the trial stage so that when these two competing sides come together, each asking about and explaining their point of view, truth will arise, and the jurors will be able to tell from this testimony and from the way the witnesses are being questioned and so on, okay, the jurors say this must be what happened or what was true. In the inquisitorial system, however, the truth is said to arise from a continuing investigation, so that the emphasis is on the screening process. So in the inquisitorial system, you have well, less so now, but traditionally an investigating judge who would get involved in the police investigation stage. And that investigating judge would serve as kind of a link to the eventual prosecution and to the courtroom. And the idea would be that anybody who gets to trial in an inquisitorial system is already assumed to be guilty. That's not a fair way to phrase it, but that's what I'm going to use right now anyway. And that's why sometimes you hear, and if you were just to ask students who might have heard about inquisitorial or just versus adversarial, they would often say, well, under the adversarial system, you're presumed innocent until proven guilty. Under the inquisitorial system, you're presumed guilty until proven innocent. As you can well imagine, overly simplistic way to look at it. But the point being made is not necessarily incorrect. Under the adversarial system, you would get to trial, well, ideally, you would get to trial more quickly, and that's where the truth would come out. Under the inquisitorial, did I just say inquisitorial? I mean adversarial if I did. Under the inquisitorial system, it's a more drawn-out process, and the pre-trial stages become very, very important as you become increasingly sure that the individual that's going to go to the court is, in fact, in all likelihood, guilty. And if he isn't, or she isn't, then the prosecutor, or the procurator under many of the European systems, would not continue the charges. This is also interesting where it gets into the politics. When you have elected district attorneys, for example, with, you can argue, very different motivations for having a case go forward in comparison to some of the European countries where you have a civil servant procurator, prosecutor, who really has no vested interest in having this case go forward in order to ensure election in the next round. They take very different approaches to this. And again, points that we're not encouraging anybody to say we need to make the United States an inquisitorial system. That's not all what we're saying. Well, some might, but that would be wrong, I think. The point instead is there are so many different ways to approach all the different aspects of criminal justice. And to only think of just the one approach that you see in television and read in your books and hear about gives you a very, very closed perspective of the world, and also cuts off opportunities that you might have for looking at ways to change things and to find different ways to adjust. The other ones up there are where does the power lie? The last one's kind of interesting. The level of cooperation expected by the defendant. In the adversarial system, the defendant is neither expected nor required to cooperate with the investigation or the court procedures. Under the inquisitorial system, the defendant is expected, not required, but is expected to cooperate with the investigation, including with court officials. The whole idea under the investigation system is that everybody is there to find out what happened. An example that I would sometimes use in class. You have, in the United States, a weapon has been found at the scene of a crime. The way that the weapon was found may or may not have violated some of the search and seizure rules. You go to the courtroom, and the judge listens to the opposing sides, and they explain, the prosecutor's explaining why this evidence should be allowed. The defense counsel is explaining why it shouldn't be allowed. And the judge has to decide, well, would this be appropriate to include or not include? Possibly more often than not, it will be included as long as the rules of search were accepted. In a German court, for example, a similar kind of scenario, the judge would want to know, well, is this gun important to know what happened? Regardless of, and this, again, I'm making a bit of an exaggeration, but the judge is saying, pretty much regardless of the manner in which the gun was found, if it was at least reasonably found, is this gun something that will help us better understand what happened in this case? And if the answer is yes, then the judge is probably going to say, well, then we need to have the gun introduced into evidence. We need to know what happened, because we're all trying to find out, defense, prosecution, the judge, everybody is interested in finding out what happened. And to that extent, even the defendant is interested, presumably, in finding out what happened. So again, an approach that sounds a little bit strange to some of our ears, unless you happen to be from a country that makes use of the inquisitorial system. Versions of plea accepting. One of the things that is also, I think, interesting is that while we have these two rather well-established ways to adjudicate a case, adversarial and inquisitorial, even just in the last 30 years since I've been looking at this area, you see more and more examples of movement from one side to the other. You see examples of the inquisitorial countries becoming more adversarial, and you see examples of some aspects of the adversarial systems becoming more inquisitorial. Oftentimes this is done, not necessarily unintentionally, but without publicly announcement that Italy says, Italy becoming much more adversarial today, Italy didn't announce, we're going to move to the US system. It's just not something a country does. But instead, you start making changes to your laws that make the process more adversarial than what it had been before. The examples that we have up here is that the inquisitorial countries moving more toward adversarial, they are adopting a practice of early and broad disclosure of evidence. What I mean is, this is inquisitorial procedures that are being used more by adversarial countries, is how that title was supposed to have been interpreted. Because what we are doing here is using more early ways to adapt to the courtroom procedures. As you know, we don't use trials that often. The pretrial stages become increasingly important for us, and to that extent we have to change in some ways. Guilty pleas become very interesting. It's another interesting point of contrast. How are guilty pleas accepted in one country versus another, and the adversarial versus inquisitorial are ways to do that. I'm going to go a little bit beyond this one. Just to get quickly to the adjudication variation, Saudi Arabia has a heavy reliance on professional judges in the courtroom. You just don't see citizens in a Saudi courtroom are not playing a role in determining guilt or not guilt. They are instead used as witnesses. They can take oaths. They can be character witnesses. They can provide some testimony, but they aren't serving as adjudicators. At the other extreme, England, for example, has heavy reliance on lay people. They have individuals, especially at the lower levels, having lay people serving as judges, sole judges oftentimes, magistrates. And in that role, the lay person, who doesn't have to be an attorney, he or she will get some training in the law to be a magistrate, but it really is a lay person doing the work at that magistrate court level. And then in the middle is where you have more worldwide variation of mixed reliance. Germany, for example, having citizens and professional judges serving on the bench together. And it wouldn't be unusual to have 3 citizens and 2 professional judges, for example. And they aren't, the citizens aren't sitting off to the side in a jury box. They are instead up on the bench with the judge. It's nice to be in a courtroom where you can actually point to a jury box and point to a bench. You know, that doesn't happen in classrooms very often. So this mixed court is becoming increasingly popular. And especially, it's been interesting to watch some of the changes in Asia. I got intrigued with the Japanese lay jury, probably about 10 years ago, and started doing some, I don't read Japanese, so I wasn't doing reading about it, but I was doing reading English translations of the Japanese and following their movement toward a lay jury. Originally, Japan had professional judges that would hear everything, and they had tried a jury system shortly after World War II, but it was not successful. They started moving in about 2009 more and more toward a jury system or the involvement of citizen judges, and in that manner became a bit of a model, although South Korea was doing a similar kind of thing in 2008 and then Japan in 2009 in terms of when the statutes were passed. Japan, to my understanding, began moving a little bit more quickly and actually implementing it, and South Korea is now implementing their citizens panel as well. And Taiwan just recently passed legislation that will allow them to do it. But anyway, the Asian countries that are moving more toward the integration of citizens as adjudicators, they have, I mean, having to change an entire system, having to convince, first of all, citizens that you should start playing a role in deciding whether somebody is guilty of the crime they've been accused of or not. And getting a group of Japanese or South Korean citizens to start accepting this as a civic obligation was not easily accomplished. And to look back at how Japan, especially since that was the one I followed more closely, how Japan went about training its prosecutors, training its judges, training its defense counsel to approach a trial in which citizens, not at all trained in law, are now going to be sitting in judgment of the person accused of the crime. That took, as you can well imagine, quite a significant effort in just training the professionals. And then the public education campaign that had to go on to convince the Japanese citizens that they were now going to start sitting on the Saibanin trials, I'm sure I pronounced that incorrectly, trials would be very, very difficult. And they went through, I mean, they had posters up in subway stations, they had movies about it, they had classroom trainings, just to convince the citizens that this was going to be a role that you're going to be playing in the near future. They have started this now, and the citizens haven't been particularly happy about it. They hear serious crimes. I'm getting a little bit off point here now, but it's kind of interesting. The Japanese courts are doing follow-ups with the citizens to see how they are handling this. On the very serious crimes, murder, rape, sexual assault, and so on, the Japanese government is offering a counseling session to the jurors after having served on a jury because it was so traumatic for them. And so not everybody, of course, would take advantage of it, but it was something the government figured out pretty quickly. We're going to need to do something with these citizens to help them get over, or at least be able to deal with, the trauma that we have forced them into. The younger Japanese citizens are able to handle it better than some of the older citizens were, but it became an issue that they hadn't fully anticipated they were going to have when they started the whole process. Very quickly now on capital punishment, and I'll just go through this because you might have some questions here. And then another interesting way to look at points of contrast, different ways to, different methods and so on. This was an article I just did for the Oxford Encyclopedia recently, Death Penalty and Capital Punishment in Comparative Perspective. The editors wrote to me and asked if I would do an article on the death penalty in comparative perspective. And I said, well, I could do that, but you'd be missing half the story because capital punishment is different than the death penalty, and I need to really talk about both of them and be able to show what the different countries are doing, and they were happy with that change, of course. So the kind of things that I was looking at as I started reviewing capital punishment and the death penalty as it's occurring around the world, as you know, about 30% of the world's countries retain the death penalty and actually carry out executions. Retentionist and abolitionist countries are defined in certain ways depending upon who's doing the defining and what kind of point they want to prove. So when Amnesty International identifies its group of abolitionist countries and retentionist countries, they have a little bit different criteria for who's included than does some other group that might do it, for example. But there's pretty much agreement, about 30%. The retentionist countries tend to be in the Middle East, North Africa, Asia Pacific, and some of the United States, as you know. Some of the comparative questions If you're going to look at how the death penalty is carried out or how capital punishment is imposed in different countries around the world, some of the questions you want to ask are, what do the retentionists and abolitionist countries have in common? For what crimes is the penalty applied? By what methods is the penalty carried out? Do the retentionist countries use similar arguments to continue its use? Do the abolitionist countries share common arguments for abandoning its use? And so the comparativists would take that initial question and would look at how the different implications, points of contrast that could be developed in doing so. Eligible crimes, very briefly, you have, well, first of all, as you probably know, international law stipulates that there hasn't been international law that has outlawed capital punishment. The United Nations, for example, in one of its treaties, is very careful to not say you can't do it. But they do say in the treaties that have been signed by most of the countries that if it is applied, it must only be applied for the most serious types of crimes. And that's about as the extent of what the international law is saying regarding capital punishment. Murder and other crimes against the person in the United States, for example, although we have a couple states where still on the books are rape and kidnapping and treason, I think, as well. But those are pretty common. But in addition to those, in some countries around the world, crimes against the state, treason, espionage, offenses against the community, drug trafficking is punishable by death in some countries. Offenses against property, robbery, arson, burglary are capital offenses in some countries. Crimes against religion, blasphemy or apostasy, especially in primarily Islamic countries, is a death penalty crime. Offenses against sexual morality. I have for example, and they didn't put anything down. Homosexuality in some countries. So those are all the different crimes for which the death penalty today can be applied. And again, you can find a country where that is actually being carried out as you look around. And again, of course, getting the data here, getting into some of the research methods and some of the problems, getting the data to even draw some of these kind of conclusions can be difficult. And so many of the data points come from NGOs, non-governmental organizations operating in the country, or Amnesty International operating in the country. And not even so much the news media, but information that is gained very quickly. Amnesty International doesn't even use China numbers anymore. They used to publish estimates of China. They've given up on even doing that. So they will say, China, we think, executes more people than any other country in the world, but they aren't. Amnesty International is not even willing to make estimates as to what that amount might be. They will make estimates of the other countries based upon everything from official records, which you can get in the United States, for example, but not official, in other countries they would rely more upon the public or NGOs or other presumably legitimate places. Methods. Hanging is the most widely authorized method and the most widely used method around the world. The others are not in a particular order, but shooting, beheading, stoning, lethal injection, electrocution are all techniques that are still used somewhere in the world to execute someone. And again, another interesting aspect of doing research in this area, and I suspect that many of you had classes in this area and are teaching in this area as well, and the idea of trying to identify humane methods to carry out an execution, and whether other countries also look at humane methods, or is the United States the only one that's doing it? And then, of course, how for lethal injection, how the different chemicals are being controlled in some ways by some of the European countries. I mean, it all gets very, very interesting if you are interested in that kind of area, I guess. Justifications. The retentionist countries usually rely upon arguments based around deterrence, retribution, and religious doctrine. The abolitionist countries more typically look at unfair application, the possibility of executing an innocent person, public opinion, and being a violation of human rights. And that last one, violation of human rights, seems to be the approach being taken increasingly by countries around the world, those that are moving toward abolition, either abolition by law or abolition by fact. The abolition by fact people are the ones that the country may still have the death penalty on its books, but they haven't implemented it for Amnesty International purposes. I think they use 10 years. So if you haven't implemented the death penalty in 10 years for Amnesty International purposes, you're considered to be an abolitionist country. But those that are moving in that direction in the last 5+ years, the arguments have been primarily on human rights violation, which are very clearly laid out in international doctrine. And so unlike anything specifically for the death penalty, you can look much more clearly to the human rights stuff. Okay, that is pretty much it. So as I suspected, and as feared, just to show you and to give you an idea for any of you who might be joining me a little bit later to talk about these things, I think it's very important to add comparative issues. There are ways that you can do it pretty easily. There are specific, this is my book, which is the best one, and there's some other people who also have been in that area, but you could get the textbooks and get some information out of that without having an entire class on comparative justice systems. My goal is just to get individual classes to incorporate that. And then I have student assignments. This is an interesting one that Sonia Ivkovic and I did on using mock trials to explain the inquisitorial and the adversarial process in the classroom. And she's used it more often than I have, but we came up with a way to incorporate a similar case that half the class would handle as an inquisitorial system, and the other half will process the class as an adversarial system. And it becomes, as you can imagine, quite interesting to see how they would do that. These are the courses that are very easily able to include in, comparative aspects to it. Criminology, you can do something on applying, in this case, Agnew's Asian strain, general strain theory, taking a general theory and applying it to different countries, because as you all know, our criminological theories are primarily Anglo-based, either US and England, and so to be able to take criminological theories and see if they apply in other cultures is very, very important. Otherwise, the theory itself needs to be modified and can't be defined as general strain. In a criminal law class, looking at how the exclusionary rule is used very, very differently in this country compared to how it's used in other countries. I just gave you an example with the German court on that one. Policing, interesting to look at the structure and how policing differs. As you know, the United States is alone except for Mexico, and some would include Switzerland, in having a decentralized police force in the manner that we have it. And that certainly affects how our policing is carried out in comparison with those countries that have a single centralized police system, for example. The Miranda equivalents are very interesting. Having students, and again, this is not an entire class. This is during a criminal law class. You have students check to see how Miranda, or what version, how do I phrase it differently? If a country doesn't have what we call Miranda, how do they, or do they at all, inform people of their rights and so on? And this one happens to be from a website that's been pretty good about keeping things updated. And they will take you to each country, and they will tell you how their version of Miranda rights are carried out. Court system, you have, I think the Japan's citizen judges, South Korea's citizen judges, interesting. There have been some interesting books on wrongful convictions and miscarriages of justice under the adversarial versus the inquisitorial system. Fascinating book, and looking at, without giving away the ending, the inquisitorial system, for a variety of reasons, tends to have fewer wrongful convictions than does the adversarial system. If you're doing corrections, the World Prison Brief is a fantastic source to get information about comparing everything from minorities in prison and other places. Comparative capstone, thank you for your attention. And there you go. And those are different sources that I've had as well. So I apologize for not leaving much time, but thank you for your attention thus far anyway. And if there are any questions, I'd be happy to take any. And if not, I'll go back to about 5 slides and keep going. Okay? Thank you. Thank you.